Peace, fam. It's your brother Usman. Today, I want to discuss the particulars of a pour-over will and why it can be a benefit to you. Now, as you know, I'm one for the private trust setup without court intervention, but many people, understandably, don't want to deal with that right now. So, as always, I give components of both sides. It's always a learning benefit to start public and then slide over to the private side. In my opinion, anyway, that's the best way to do it. But throughout the learning process, you still need to have your assets and property protected. So I'm going to cover the components necessary to constitute a pour-over will in detail and a few not too revealed aspects of the trust will structure, or i.e. pour-over will. Now, in all honesty, if you have only a will to deal with the distribution of your property after your passing, that's kind of short-sighted. And the reason people usually do wills only is because they have not really set up a device for the distribution of their property, not a proper device, or to deal with their estate once they pass. Truthfully, a will is for people who either feel they don't have much or don't feel competent enough to design a plan for the distribution of their property. So they basically put a few wishes down on a document and let the courts deal with it. Not knowing, though, that when wills go through probate, and most of them must go through probate, the courts have full control of your estate. And no matter what the financial disposition of your family, they can give your estate away to a creditor who may or may not have a valid claim. And that's just one of the ways the estate can be taken away from your family. Courts have hundreds of cases and mountains of paperwork. And that's usually paperwork only they understand, which translates into time and cost, which can devastate an estate economically. So the bottom line is it's not smart to have a will only. Ultimately, you want to have as much autonomy over your estate as possible. But in the meantime, you do want your family to be protected in the event that, something happens to you. You must have a trust in order to better ensure the protection of your assets for your family and even for your legacy. A will, more specifically a pour-over will, can supplement your trust and kind of cradle your estate and a safety net to make sure it stays with your family, or at least the proceeds of your estate. But a will alone is the bare minimum and really has big limitations on the certainty of providing for your family and for your beneficiaries. And you can pick up the phone and ask any attorney about the fact that a judge has the power to overrule wishes put into a will because a will is amenable to the courts. But trust property is not directly amenable to the courts. Your property, once you put it into a trust, cannot be attacked without the court opening itself up to an appeal. So a pour-over will is really a will with a clause or provision that names a trust that can receive property from the testator's estate. Okay, here we have the will and the trust, and as you can see, they look pretty similar, and that's because they're the same species of contract, so to speak. Now, I cover the similarity in contract styling in my course, but if you're familiar with contracts, you know why they look so similar. Okay, so here's a simple will, and they get much more complex than this, but this is just a pretty simple one, just for the sake of expediency. And it has all of the enumerated sections of a standard will, all of the articles and titles. And when we get to the disposition of property, okay, here in Article 2, we see that the testator has granted his property to his living trust through his trustees, incorporating by reference the terms of this living trust. So he just basically mentions in the disposition of his property that it is to be transferred into this trust. You can also incorporate the terms of your trust into a portion of your will. okay? Or rather, you could have your will be dictated by the terms of your trust. That gets a little complicated, but we will cover that in later presentations. So now let's say you own a house and a condo and 2 cars. Your house and the condo and 1 car are in the trust, but 1 car is not. Your will simply state that upon your passing, you want that second car to go into your trust. Now you can name it specifically, or you can just name that all of the property or all of a specific portion of property go into the trust. Okay, so again, you can get creative with the trust or with the pour over clause of your will. All right, and your situation can be simple, or it can be more complex, but that is essentially how a pour over will works. Now, even though it may not be mandatory to have your estate probated through court, when you combine a will with a trust in this fashion, there are some advantages. First, your trust is put on the record as existing through court record. The trustee is announced to any family members who might think they have a claim to property, so there's no ambiguity about who runs what. Also, the added flexibility of having a will with the trust is that a will allows you to arrange things that don't really apply to trust administration, such as naming guardians or for children, naming the way you want funeral services done, saying your last goodbyes, things like that. Also, you may want to keep some of your property out of the trust to have assets with high liquidity in case of emergency. If you have expensive jewelry and trust and you need money right away, it's a lot easier to snatch it out of the box and go sell it rather than to have to get an okay from a trustee and or update your trust inventory and your accounting. So again, the will in this video is simple, but they can get very complex. You can get into who pays taxes, divide certain property between certain people or institutions and other properties of the trust, apply severability. Like any other contract, a will can be as broad as your imagination with respect to, the lawful parameters. Now, even more powerful is the addition of a competent executor to this mix, which could cover you even if your trust has certain administrative flaws. And I'll say what I mean by that. For example, if certain items in your trust are not properly transferred and there's an issue, say with a car that was not properly placed into the trust, someone who is adversarial can dispute the granting of the car into the trust. And since it may be found by the court to be improperly titled to the trust, that adversary can try to claim the property, and without the proper verbiage in the will, they can drag your family through a prolonged court process where now only the court gets to decide what happens. And how you circumvent that is you designate an executor, maybe a spouse, to work in concert with your trustee and give him or her power to transfer any non-designated or neglected properties of the estate into the trust. This basically gives your trustee and your executor joint control over the entire estate. So items outside of the trust are safeguarded by the executor, who will turn them over to the trustee. And this will all go on court record, quashing stragglers who might be trying to come at the 11th hour and claim property. If you can imagine putting all your property in your trust, and after 3 months of going to court to distribute the property, in the last few days they find out that something wasn't properly placed into the trust, and a family member wants to lay claim to that property. Now you're looking at a court battle over the property, additional court fees, additional lawyer fees, etc. It can get painful. So your will can serve as an announcement of your trust, and any other information you may want the family to know on the record, you can put in that will. While the trust keeps the disposition of your other properties away from those not invited to that information. So remember, anything on the will becomes public record, including social security numbers, addresses, what have you. Keeping that in mind, all you have to do is reference your trust on the will. No need for details. The fewer the details, the better. The law only requires that you incorporate the trust by reference, that doctrine, um, and that you name the trust. That's it. You don't have to name any particulars other than that. The name of the trust, perhaps the date that when it was started. But even that, just the name of the trust. That's basically all you need to do. Um, Also, a will cannot dispose of property held by tenants in common. So if you and someone bought a building or a property together, and this is not really including like a married couple, because the laws of descendancy and community property will come into play here. The will has no binding on that. It has no attachment to that. Okay, but to say if you are with a business partner, you guys bought a building, be it commercial or another house or rental, whatever the case may be, and once you pass, your interest is automatically relinquished. Now, what you can do in your pour over is to, or in any will basically, is to pass that interest on to a successor, or um, confirm that all of the interest into that business partner, so that they have all of the interest, they have all of the ownership. That's basically all you can do with the will in terms of joint tenancy property. Um, the will cannot alter or claim as probate assets life insurance policies, health insurance policies, any contract, any prior contract that is a binding contract, where beneficiaries are already designated. You cannot claim those as probate assets. All right. And also, some jurisdictions, or some states rather, put aggregate caps on how much value can be transferred via a will into a trust, meaning that some states may say $100,000 worth of property is all you can transfer via a will into a trust. So if you have a $200,000 house, you cannot, if your state caps you at $100,000, you cannot transfer via your pour over that home into your trust. You can get complicated again with the will and transfer the interest or certain parts of the interest, but that gets into other devices that you have to structure and other things that you have to do, as you might imagine. Um, so, all in all, setting up your trust with the will can save money in the probate process. Everyone knows that the bulk of money made by the courts are from ambiguities and mistakes in paperwork, or failure to file paperwork. It takes time to clear those things up, and time is money, especially in the judicial venue. So, as I mentioned, with the right verbiage, any item found not to be in or properly transferred to your trust can be caught by your will and safely shuttled into the trust where it was intended to be. It can be your built-in contingency plan, if you will. And generally you have a very good chance that the wishes of the testator will be followed. But as I always remind people, when you deal with courts, nothing is guaranteed. Wills put the estate in court. Assets transferred under a will are still subject to probate rules. So, remember that. Your executor and trustee may well have to enforce some of their rights in this court process. And any attorney should tell you that. All right. So now the things that a pour over will should have are as follows, and we'll go into it. Okay, so these are the things that your pour over will should contain. Okay, that's this article here. It, of course, should have your basic standard testament articles, announcements, and articles, and their titles. It should, of course, denote the state of mind and the voluntary action of the testator, okay, in his execution of the will, his or her execution of the will. There should be executor appointment, of course, This is the person that's going to carry out all of the wishes of the will, which is going to be separate from the trustee of the trust. They're going to work in concert, as I explained before. You're going to have your statement that all prior wills are nullified by this particular will, this most current will. You're going to denote who pays for your funeral expenses and all of your outstanding debts in particular. And this is very important because if this is left out and there's problems with people paying your expenses, be they medical or funeral expenses or what have you, those people who bear the burden of the expenses are going to want to recoup that money. And guess where they're going to try to take it from? Your estate. Okay? So this is a very, very important article. All of them are important, but this is one that's crucial. Without it, you could have people laying claim to your estate justifiably and have things turn nasty. Now, you can name the trust property that's going to be put into the trust. You can name it specifically, or you can just name it in general. As this states, it just says all of the property that I own at my death, assets or payouts to my estate or representatives, and any property under my power of disposal shall be distributed to the trustees of the John Doe Trust to be administered according to the directives and provisions of the John Doe Trust. Okay, so this is basically a catch-all. Now, again, you can do specific properties, or you can do general properties, or you can do what's called residual property. Again, these can get complicated, or they can be simple. Of course, you name the trust, okay, as it does here. This is a different name, but we're just going to, for the sake of the video, say it's the same name. Failure to name the trust in your will invalidates the pour-over, plain and simple. Unless you have a very compassionate judge. Okay, and those are the main provisions you should always have in your pour-over will. There's a complicated style. One, say if someone's married with children and has property, I will be going over that will later down the line. So, stay tuned for that. All right, fam. So in closing, let me remind you that trust law goes beyond the trust instrument of just holding property or managing estate and assets. Trusts are like people, and that avenue is my most preferred approach. It entails a lot of information not readily available. So, stay tuned and we'll be on our way to a more unified understanding. Peace.